Good afternoon, everyone. Welcome to the EFC webinar on euthanasia and physician-assisted suicide in Canada. The focus of today's webinar is on what we as Canadians need to know about this issue. Canada is grappling with how it will usher in euthanasia and physician-assisted death since the Supreme Court lifted the ban last year. I'm Karen Stiller, an editor with Faith Today magazine, and we're joined today by Bruce Clemenger, President of the Evangelical Fellowship of Canada, and Julia Beazley, EFC's Director of Public Policy. We welcome your questions throughout this webinar. Please use the chat option on your screen to send them in at any time, and we will do our best to interact with all of them. To get us started, Bruce, can you walk us briefly through the timeline on this issue? What has happened since the court lifted the ban last year?
Sure. What the court did is there was a prohibition against assisted suicide and euthanasia in Canada. A Supreme Court in February 2015 issued a landmark decision which basically said that in certain circumstances there should be some exemptions to the blanket prohibition against assisted suicide. They suspended their decision for 12 months, which gives Parliament basically 12 months to craft a resolution to what the Supreme Court said. And of course, amidst all that, we had a federal election. So the federal government went back in December and asked for an extension. Supreme Court ruled last month and said that they'll give the Parliament 4 more months. So they suspended again their decision until June 2016. So they have 4 more months to craft legislation which would accommodate the Supreme Court's decision and place it in our criminal code.
Okay, and so the laws that are being that will be crafted will place some restrictions around physician-assisted suicide and euthanasia. Is that the point of the laws?
Yeah, basically what the Supreme Court did is to assist someone in suicide is a criminal code offense. And the Supreme Court felt that in certain circumstances, if people meet certain conditions, that they should be in a sense exempted from that blanket ban against assisted suicide. And so they used some language in their decision to describe the situation in which a person could be exempted. But remember, it's still a criminal code offense. So their task is to rewrite the criminal code provision about assisted suicide, allowing for certain exemptions.
Okay, great. Thank you. That's helpful. Julia, the EFC has been involved with this issue since the beginning, and certainly since the ban was lifted last year. What is the EFC doing now? What do we need to know?
Yeah, as you said, we've been actively involved in these discussions for a lot of years, certainly since the early 1990s. We also intervened in the Rodriguez case, which was kind of the first case that brought these issues before the Supreme Court of Canada. In terms of where we are today, we were involved as an intervener before the Supreme Court of Canada in the Carter case. And since that ruling came down, we've written to the Ministers of Justice and Health. We've been involved in responding to proposals from some of the provincial colleges on how they might deal with the issue of protection of conscience for physicians who don't want to participate in assisted dying. And in the fall, we made some submissions. One was to the Provincial Territorial Expert Advisory Group on Physician-Assisted Dying, and we made an appearance before the Federal External Panel. This was the panel that was struck by the previous government to kind of hear from people and make recommendations back to the government on what their response to Carter should be. And most recently, between Bruce and I, we attended all of the committee meetings. So this is the Special Joint Committee on Physician-Assisted Dying, a committee that's made up of members of Parliament and some senators. And we made a written submission to that committee, which is available on our website. So we've kind of been engaged all along. We will remain actively engaged in the process as the committee tables its report and legislation is brought forward. We've also been working with other faith groups, trying to determine together how can we best respond to these issues, how can we magnify our voice and our influence. And this included our work with the Canadian Conference of Catholic Bishops in writing the Declaration on Euthanasia and Assisted Suicide.
Okay, Bruce, could you unpack for people who may not be aware of it what the Euthanasia Declaration is that Julia was just talking about, and what difference it's having or that you hope it will have?
Originally, it was a statement that we worked on with the Canadian Conference of Catholic Bishops, just to frame out our deep concern with the permitting assisted suicide and euthanasia, even in limited circumstances. A strong affirmation of a respect for life, the sanctity of human life. A strong appeal for strengthening our palliative care availability across Canada. And last, a request or urging governments to respect the freedom of conscience of doctors and also institutions that may be caught up in assisted death. So originally it was a statement that was signed by the EFC, by the Catholic bishops, by a number of our denominations. A number of the Orthodox denominations signed on, a number of Jewish and Muslim leaders representing clusters of rabbis and imams. So it was kind of an interfaith kind of declaration that was released in October. But since then, we've opened up the declaration to individuals. And so people can go to euthanasiadeclaration.ca and lend their name to it. We're closing in on 15,000 signatures. So really it's a kind of a public statement about our concern about the direction our country is going if we legalize assisted euthanasia and how we can respond with better palliative care and protection of conscience.
And one statement in the declaration talks about the duty of care we owe to each other. I'll quote from it. Assisted suicide and euthanasia raise profound social, moral, legal, theological, and philosophical questions. Questions that go to the very core of our understanding of who we are, the meaning of life, and the duty of care we owe to each other. I'm wondering if you both could sort of unpack that a little bit and talk about, I guess, what that statement says to me is how core this issue is, and this idea of duty of care really jumps out at me. What do we mean by that, and how can we be better at that?
Again, the declaration is framed as a document of a number of faith religious leaders, and actually across religious traditions, whether the ones that signed at the outset were Muslim, Jewish, and Christian. And we all have, within our own religious traditions, a strong element of the duty of care that we owe one another. As Christians, we understand or we believe that we're created in God's image. So we're all image bearers of God, and that we are to care for one another. The question posed in Genesis was, am I my brother's keeper? And in a sense, yes, we are. And so throughout Scriptures, Old Testament, New Testament, we're told to care for the widow, care for the fatherless, care for the alien, the stranger, care for those who are ill, care for those with disabilities. It's across Jesus' ministry, but also across Scripture. So in that sense, we believe that we are our brother's keeper. We owe a duty of care to one another because we're all God's image bearers, and we are to care for that which God's loves. So we love God, we love our neighbors, ourselves, and that's expressed in a duty of care. Also, however, we've kind of recognized that in Canada. How do you explain our universal health care system or our medical system other than that we realized in Canada that we have a duty of care to one another, so that we will care for, in terms of health care, social services, a whole range of things that we offer as a Canadian people to one another, that we kind of share that understanding of duty of care. So we wanted to reinforce that. We believe that out of our religious traditions, that we have a duty of care owed to one another. And in this context, particularly as someone's nearing death, as Scripture put it, when they're walking in the shadow of death, that we need to be caring for them, to come alongside, to offer companionship, love, and practical ways of caring. But that also is something that our society has recognized as well.
I'm wondering, because you talked about the religious groups that came together to create this very powerful declaration, and that this is a belief that crosses over through lots of religions, obviously, but how are we being dismissed because people view this as a religious position, that euthanasia and physician-assisted suicide is not a good idea? How are you able to speak into that as people of faith?
Yeah, often it's actually come to the point that's put on it is, why are you trying to impose your morality on us? It might be You might believe it's wrong, but why is it then wrong for us as well? And again, the response back is, well, the quick response to imposing morality is that we can't do that. The government does. It's called the criminal code. So the criminal code is the common kind of applied morality of Canada, which dictates the kind of things that are not allowed and assigns sentences or penalties to that activity. But stepping back again, back to this idea of duty of care, one thing the Supreme Court grappled with is the basic commitment in Canada to respect for life or the sanctity of human life. And they call that kind of a core value, a core principle of Canadian society. That goes back to the Rodriguez decision that Julia mentioned some 20-some years ago, as well as the current Supreme Court. And so within that principle, they understand that within not just Canada, but actually Western society, there's this underlying respect for human life, and that's something that again shapes our social policy, our healthcare policy, our medical systems, and so on. And so it's a broad-based concept or principle that infuses and animates kind of our common life together. And our concern is that if you allow assisted suicide, even in certain legitimate situations, you're going to begin to undermine that respect for life. To put it simply, in Rodriguez's decision 20-some years ago, the Supreme Court weighed individual autonomy and respect for life, and they 5-4 said that respect for life is so important that we can't allow exceptions to it. Otherwise, that might undermine that principle and undermine our commitment to sanctity of human life. In this, in last year, the Supreme Court 9-0 erred on the side of human autonomy, still respecting respect for human life. But what they said is that we must balance these things very carefully. So the decision was very much a delicate balance between autonomy and respect for life. And their concern was that they felt that we could make limited exemptions to the blanket prohibition without undermining respect for life, and that's what we're concerned about.
Okay, and just as a reminder to everyone that when we talk about the Rodriguez case, that's the Sue Rodriguez case, just if that helps jog people's memory. And I think that was, like you say, about 28 years ago. We've had a question from a participant, and this, I think, spins off nicely from what we were just speaking about. Other countries' experience with euthanasia, other countries who have also dismantled laws around it and ushered it in. What can we learn from them, and what has the effect been in other nations? Julia, do you want to tackle that?
Sure. They talk about the Benelux countries, and I don't know where that term comes from, if it's an abbreviation of the names. We have Belgium, Luxembourg, the Netherlands, and these are countries that have been quite permissive in allowing euthanasia and assisted suicide. And I think one of the things we can learn is that the safeguards are not always entirely effective. They have found, evidence that they're not complied with all of the time. So one of the things I think that we have been saying from what we've learned from these countries is that the safeguards are never completely safe. But the other thing that's a little bit different is it kind of feels like we're starting a little bit further down the road than a lot of these countries did. Something about talking about the inclusion of children or minors, for example. It took some of these other countries quite a bit of time to get there. They started out a little more restrictively and have gradually become a little bit more permissive in what they've allowed. And I think, Canada, we're sort of looking at the experience of these other countries and starting off a little bit further down the road, which is a bit alarming, because it's a big shift for us here in Canada. So we've been urging, caution, restraint. Let's stick as strictly to the principles of Carter as we can if we're in fact going to go down this road. Yeah, there's all kinds of evidence that, things, as you would expect when you create a culture where assisting in death is not just permissible, but it's almost desirable. It does have an influence. It has an influence on how we look at life, how we understand life, the pressures we feel as individuals when we experience illness or a traumatic injury, the sense of, one of the MPs said in one of the committee hearings, you know, when does the right to be assisted in death become an obligation to be assisted in death? So these are the kinds of things that we watch what happens in these other jurisdictions, and we say, you know what, we really have to be mindful of these things as we go down this road.
I think also, if I can, that's one of the things of the Supreme Court decision, in the Carter decision, the recent one, was again this balance between respect for life and human autonomy. And the Supreme Court felt that it would be possible to create really stringent safeguards and develop a system that would protect vulnerable people. That would mean that the exemptions would be very limited indeed, and that wouldn't undermine the broader respect for life. And that's where our concern is. The evidence from other jurisdictions that wherever they've set up safeguards, they seem to be, there still seems to be wrongful deaths that occur. And so that's why we've erred on the side of, again, promoting the sanctity of human life with no exceptions, because every jurisdiction that we've seen, there are examples of wrongful deaths. So that's really where the Supreme Court turned between the Rodriguez decision and the Carter decision, most recent one, is it possible to set up kind of restrictions and safeguards that protect vulnerable people from wrongful death. And that's where the previous court, 5-4, thought they weren't able to do that. The current court, 9-0, thought that we could. And now it's in the hands of Parliament to see whether they can come up with those kind of safeguards that will actually be foolproof. And that's what we're skeptical about.
Two thoughts. One, when we think of other countries, it seems to me that the term that we use often, perhaps slippery slope, is sort of perfect for this example, where things start in one place and then it seems relatively quickly get worse. And also, we've brought up the Carter case a few times. I'm just wondering if one of you can give a very quick explanation of that for people who may not, this issue may be new to them, or they may not be aware of the legal ins and outs of that. Can someone just give a quick summary of the Carter case?
The Carter case it was the one I was referring to at the outset that came down in 2015 in February, and basically it was dealt with actually two women. One last name is Taylor, one Carter, and it was again their request. It was their challenge under the charter of the blanket ban on assisted suicide euthanasia. So in the Carter decision, the court decided that they would allow limited exemptions. They thought that they could put proper safeguards around around the practice, and that would be very limited, but that in certain circumstances, when a person, what they called was grievously and irremediably ill, was suffering in pain and discomfort that was intolerable for that person, that in those kind of conditions, that they should be allowed to be assisted in their death. And so the question is, what does grievous and irremediable mean, and what are the conditions? And that's where, in terms of slippery slope, we're in a situation now. Now the debate is Carter seen to be that delicate balance, and is going to be read very, very narrowly. So it involves someone who is terminally ill, who has a degenerative condition. So it's not a stable condition, but a degenerative condition, that they are near death, and that they're no longer able to take their life themselves. They're no longer to commit suicide. Therefore, they need someone's assistance in committing suicide. So, and it's an adult, and they have to be competent at the time of death, et cetera, et cetera. So we're going to have a narrow reading, or we're going to have more of an expansive understanding of what Supreme Court did. And so during the committee hearings where Julie and I attended, quite often they referred to Carter as not as a delicate balance, but as the floor. And so if Carter is the floor, then what's the ceiling? And that's where they started challenging or brought out the idea that what about children? Should it be available to competent minors? What about advanced directives? So do you need to be, at the time of your assistance of your death, do you need to be conscious or competent, or can you sign a document 2 weeks, 4 weeks, 2 months previously that would enable someone to kill you? Those are should mental illness be a condition upon which you could achieve or be given assisted suicide. So that's where so in a sense there's no slippery slope at this point. It's kind of if Carter's the floor, then how far, where's the ceiling? And that's all live debate now. So that's why when Julia said in other countries, they kind of moved step by step and kind of expanded the practice. In Canada, with the Supreme Court decision, there's actually a live debate that would actually leapfrog us, as close to where Belgium is or even beyond.
Karen, I think actually that's, if there's anything we sort of want people to understand at this point, is that I think that most Canadians, we keep hearing from the committee and from witnesses that Canadians want this, Canadians want this, Canadians say they want to have this right. But I don't think that Canadians fully understand the conversation that's actually happening. I think most Canadians feel like what we're talking about is what was before the Supreme Court in Carter. We're talking about adults who have a terminal or degenerative illness who wouldn't be physically capable of taking their own life. And, you know, I think a lot of Canadians probably do have sympathy for that kind of idea. But what's happening, the conversation, as Bruce just said, has gone so far beyond that, that we are talking about including individuals who don't have a terminal illness, who don't have a degenerative illness, you know, individuals who may be suffering from a mental health issue, some sort of psychological suffering that to them is intolerable. As he said, mature minors or mature children. So the conversation has gone so far beyond what I think even the Supreme Court envisioned in their ruling, and it's gone so much broader. And I feel like that's not getting translated in the media, that people are maybe not hearing what conversation is actually taking place. And yeah, so I think that that's something important. We're trying to figure out how can we help get some of that news out there so people understand the conversation that's actually happening.
A participant has asked, is there a chance that we could have an issue, the same situation as we have with the abortion issue, that there won't be laws to govern this?
You know, actually some witnesses before the committee have suggested just that the federal government take a very hands-off approach, so sort of really restrict themselves to just amending the criminal code to allow assisted suicide and euthanasia, and then just leaving the rest to the provinces and territories to regulate. A lot of other witnesses, including the EFC, maintain that the Supreme Court didn't really provide that as an option. They have to legislate. In fact, because, as Bruce said earlier, this is an exemption to a criminal code prohibition on killing, criminal code is federal jurisdiction. So our position is that the federal government is obligated to legislate on this issue, and because within their decision the Supreme Court talked about enacting these stringent safeguards, you know, the importance of, yes, if we do this, would there need to be very, very stringent safeguards in place to make sure that there are no abuses of this, that the vulnerable are protected. So I don't think we're going to end up in a situation where the government does nothing. The question is, how far will they go? They could just choose to amend the criminal code and not do much else, but we're hoping that they will hear an awful lot of the voices who are saying, you know what, this is something that really should remain, at least to a certain extent, within the purview of the federal government, to make sure that we have uniformity across the country, that we do have those safeguards in place as best as we can.
The other, just to follow up on the abortion analogy, I guess another place that there's an overlap is in the whole issue of whether the court mandated or found a constitutional right to assisted death. And that's where we're arguing back. What the Supreme Court basically said is that a person in certain circumstances should be able to request assisted suicide, and that the court envisioned a doctor should be able to help them kill themselves in certain circumstances. But there's really nothing in the decision that said the government must, nothing that mandated that the government provide assisted suicide. So it's more of an exemption from a criminal code offense, so that enables me to do something that otherwise I'm not allowed to do. But there's nothing in the decision that actually mandates that governments actually provide assisted death. So that it take place in hospitals, that it be funded through provincial health plans and so on. So the parallel to abortion is that when the Supreme Court struck down the laws on abortion, they didn't do so because they found a constitutional right of a woman to have an abortion, but they thought that they felt that the availability of abortion was inconsistent across Canada, so they struck on the law on that basis. But they never found a constitutional right to. So while governments can provide abortions, they're not required to. And in this case, it's a similar situation, is that, again, this is an exemption from a criminal code, so it enables you to do something that otherwise you're prohibited from doing. But there's nothing in the decision that suggests that governments then must help you do it.
Okay, could you comment on the federal-provincial tangle here? Like, we know that someone has died in Quebec already from this, and just help us understand what's happening in Quebec that's different, if it is, and also, yeah, what are we talking here with jurisdiction and federal and provincial? Either one of you.
Okay. Well, in Canada, the criminal code is federal jurisdiction. So it's so that we have a uniform kind of moral code across Canada. Healthcare itself is provincial jurisdiction. So that's up to the province to decide how they're going to deliver healthcare. The only control the federal government has is through the Canada Health Act. And so we give provinces money every year from the federal government gives money to the provinces and asks them to respect the Canada Health Care Act. That's the only jurisdiction the federal government has. So it's kind of a carrot kind of an approach. So on this issue, the question is assisted, it's often called assisted death or physician-assisted death. Is that primarily a criminal code matter, or is that primarily a medical matter? So what Quebec did is a few years ago it moved towards passing legislation which they refer to as medical aid in dying. So the Quebec government basically says, well, assisted death, assisted suicide is part of the continuum of care within broader medical practice. So you have palliative care, you have palliative sedation, then you have assisted death or euthanasia. They see it as part of a continuum of care that is medical and therefore is provincial. So they went ahead and passed legislation in defiance of the federal government's ban on assisted suicide. They went ahead and made it and decided that it should be legal in Quebec because it's provincial jurisdiction. The federal government really should have pushed back and said, no, it's, this is, criminal code is ours, not yours, and we have the final say. And that's where there's this kind of trade-off and balancing act between the two. So in terms of the federal jurisdiction, whether you allow assisted suicide or not, that's kind of federal territory. When you get into provision of assisted suicide, that's understood to be more provincial because it's not only within the ambit of medical care or social services and so on, but also it falls, if doctors are going to be performing assisted suicide, they're regulated by colleges of physicians and surgeons, which are established provincially. So there's this kind of interesting, for Canada at least, there's this kind of jurisdictional difference within Canada that actually doesn't exist in any other jurisdiction that's allowed assisted suicide. In all those jurisdictions, whether it's Belgium or Holland or whether it's Oregon, the one government is responsible both for the criminal code offenses or the law as well as responsible for the provision. And that's where in Canada it's in different jurisdictions, so that just adds to complexity.
Yeah, there's been a lot of there were a lot of different opinions before the committee about how far the federal government could go. They could, for example, when we talk about eligibility criteria, they could define, it has to be an adult with a terminal degenerative illness. They can say it has to be an adult. They can probably establish what makes you eligible. So whether or not psychological suffering alone would make you eligible. When it comes to things like how you assess competency, capacity, consent, these things, the provinces already have different kinds of legislation and policies for medical professionals in terms of assessing these things. So that's, once you get into that kind of thing, it was a little less clear how far the federal government could go, but they could say in whatever they craft in the criminal code, you have to ensure that the patient has freely consented, has been fully informed, is competent at the time of provision, and that kind of thing. So I think the more sort of detailed you get into how the actual provision would happen is where you sort of step into more of the provincial jurisdiction. But because this is an amendment to the criminal code. We were kind of, we're hoping that they will write as much of the safeguard procedure into that as possible.
Oh, sorry, a participant has asked if most members of Parliament you've talked to understand and appreciate the concerns that are being expressed regarding the risk of legalizing euthanasia to the vulnerable within our communities here in Canada. So do politicians get it when the EFC goes in to talk?
When we have a chance to explain it to them, I think they understand it. But again, this is kind of a new issue for them. There's so many new MPs in this new Parliament. Previously, since 92, 93, and the Rodriguez decision of the Supreme Court, there were a couple of Senate committee hearings. There was a series of private members' bills, all on this issue or surrounding this issue. And so Parliament has looked at this issue a number of times in the last 10, 15 years. And so MPs that were in Parliament during those years will have thought about this, will have heard it debated, will have studied it. A lot of the new MPs, this is brand new to them. So I think that's where we need to get the message out. We need people to engage with their members of Parliament, explain to them what you believe, what you think about this issue, but also help brief them on some of the details. Because right now we've had a committee of I think 16 members that have been looking at the issue, and there's some additional members participating. But in terms of the broader range of MPs, this hasn't really come to them yet. And so now is the opportunity for people to engage with their MP and to brief them. And we're going to be developing briefing materials, and we'll develop a submission that we can distribute. But I think there's, as Julia said, I think there's still the general perception, I think amongst politicians as well as the general population, that what the Supreme Court is is crafted a very, very narrow exemption for people in particular situations, and they really haven't studied the issue of safeguards. They really haven't studied how broad those definitions could become and how many people could be encapsulated by those definitions. I think it was Margaret Somerville, ethicist from McGill, said in her submission that if you look at Belgium or the Holland and see how many people die by assisted death in those jurisdictions, and then prorate that to Canada, we're talking 10 to 12,000 people a year. So it's not very narrow, it's not very limited, but possibly very expansive.
Let's shift gears a little bit and talk about the connection with palliative care. For Faith Today magazine, I did a story on palliative care and euthanasia in Canada, and what everybody, the experts I spoke with, said very clearly was that there is a problem with offering euthanasia and physician-assisted death in our country before we have national, accessible, excellent palliative care available. That it's almost, putting the cart before the horse, to put it lightly, I guess. And I'm wondering if you could respond to that, and how the EFC is also involved in the issue of palliative care.
Basically, again, in the Carter decision, they framed this crafting an exemption as a choice. They said people in these circumstances need to have a choice for assisted death. And the question is, do you really have a choice if you don't have an alternative? And palliative care very much is that alternative. Palliative care is not just about pain management. Palliative care is much broader than that. It's really an interdisciplinary way of coming around, surrounding someone who's nearing the end of life and experiencing pain, where we have a strategy of kind of holistic care. It involves kind of a spiritual dimension, involves social workers, involves caring for the family as well as caring for the patient. It's medical, psychological, social, emotional, religious. And the sad fact is, in Canada, I think the argument is only 16 to 30% of Canadians have access to high-quality palliative care, depending on whether you're urban or rural. So there's not a lot of good access to palliative care. There's only a limited number of hospices or facilities that are wholly committed to palliative care. Usually palliative care is experienced in hospitals. And so what we're calling for, and we've been doing this for many years, calling for kind of developing that the government develop a national palliative care strategy that would address the need for making sure all Canadians have access to high-quality palliative care. And again, this is where the federal-provincial jurisdiction issue comes into play, because the delivery of palliative care would really be under provincial jurisdiction. But I think this is the time the federal government can play its role of kind of being a leader of a federation or a confederation, and say, okay, we need to establish good palliative care goals across Canada. We need to make sure the Canada Healthcare Act reflects the need and the responsibility of province to deliver high-quality palliative care. So we need to train doctors, we need to train social workers, but also we need to figure out ways to facilitate palliative care. Most Canadians want to die at home, and most Canadians end up dying in hospitals. So how can we alter some of the funding models, alter some of the structures so that dying at home it becomes more a possibility for Canadians? And making sure that people aren't just institutionalized, but feeling that there's a community surrounding them that supports them. And so at EFC, this is one of our major initiatives, is not just to argue about and oppose the legalization of assisted suicide, but make sure that good palliative care is accessible to all Canadians, and make sure that our churches are mobilized to care for people who are in the shadow of death across Canada.
One thing that came out for me as I researched that article was just, it felt like there was so much maybe misinformation out there. This idea that a lot of people die an agonizing, extremely painful death, and that really the fear of that is what drives their potential desire for physician-assisted suicide, when in fact, when they are reassured and informed that their pain will be managed, and there's people typically do not die like that, the demand for euthanasia decreases dramatically. Could you comment on that, Julia? Is that what you've seen? Is that part of the problem?
Yeah, we see that in the, whether you're looking at research in terms of why do people request assistance in death, it's usually things like fear, isolation, loneliness, despair, all of these things. And this is something that we pushed the Federal External Panel on. I say them particularly because that was a presentation live, and we talked about the difference between pain and suffering. And pain is sort of a medical question. It's something that the medical community is equipped to address. But when we talk about suffering, it's sort of this more fully human question, and it has all these different elements to it, and medicine alone is not equipped to deal with that. So that's why all of, Bruce talked about palliative care and all that brings to someone. We're talking about caring for the whole person. So one of the things, the committee heard from all kinds of witnesses, the Canadian Palliative Care Association and palliative care physicians, and they told these incredible stories of patients who had made requests to die, but in a context of receiving good palliative care and having all of those human needs met and addressed, they talked about the shift that happened in almost all of them, in terms of coming to, terms with their condition, making peace with it, being surrounded by people who were caring for them and walking with them. And there were just some really beautiful, touching stories about kind of the process that happens in people when they receive that kind of care. Now, I may not in every single case alleviate the desire for death, but it does seem, certainly from what the committee heard, that in most cases, just having that kind of setting, I have talked with people who walked through it with family members, and even for the family to be surrounded by those kinds of supports and resources is completely invaluable. So one of the most important things is that we make sure we have this kind of care available to all Canadians. It's not unlike kind of what we would hope the federal government would do in terms of housing, kind of establishing that national priority, that national strategy, kind of setting the standard, saying this is what we want in terms of quality and availability for all Canadians. And then, of course, the actual delivery of that is done mainly by the provinces. But it's kind of setting that standard that says we see the importance of this, and we know that this is paramount. So we will be working on encouraging the government to take action in that, and also, as Bruce said, working to bring faith communities together. How can we become actively involved in participating in providing that kind of care for people.
If I can, another issue is the will to move ahead, because palliative care, this kind of national strategy implemented locally, it does cost money, and it'll take a lot of energy and ingenuity to make sure that we have a broad-based system. And the concern is whether once we, if we legalize assisted suicide euthanasia, will there still be that strong will to develop palliative care? The concern is that in countries like the Netherlands, they aren't as strong in palliative care as other countries like England, which does not allow assisted suicide but has a very, very good palliative care regime. The other thing is that whether people are in favor or oppose assisted suicide, pretty well everyone agrees that palliative care must be improved in Canada. I was joking that pretty well every organization that appeared before the committee that had Canada or Canadian at the front of its name, Cancer Society, Palliative Care, Medical Association, all those large national groups, all of them pushed hard on the importance of having good quality palliative care available across Canada. Some of them hadn't decided yet about assisted suicide in terms of official policy, but all of them kept repeating the importance of having palliative care. Because there is really no choice if you're nearing the end of death and say, well, I'm sorry, we can't manage your pain, but we can offer you death. That's no choice. No. And so it's too bad that, again, it's actually a shame that we're having a debate about assisted suicide in advance of actually having good quality palliative care accessible across Canada.
One of our participants has asked what church leaders and pastors can do within their church families regarding this issue, and what is the best way to help communicate our concerns to federal and provincial representatives.
Well, for one, we would encourage them to look at the Euthanasia Declaration if they've not already signed it, to encourage their church members to sign it. Not
and
just
that's
because
online, Julia,
that
right?
is online, euthanasiadeclaration.ca, I think. And that's not just because we want to have as many signatures as possible, but also because it's a really good piece to sort of inform and help people understand, okay, if I were to talk to someone about this, what kind of language might I use? What might I say? So it's a really great document that way as well, also in terms of just the asks. We have also just put up some information on our website, kind of an action piece with a bit of an overview of where we're at, what are we dealing with, and what are some action steps that people can take. I can't think of the direct link to it right now, but it is on our website, and there is a sample letter there if people want to use that to write to their member of parliament, or just sort of use some of the language to make a phone call. So I would encourage church leaders to sort of check out those resources and make them available to your communities. Talk about it from the pulpit. We've talked a lot about the idea of suffering, and how are we within the church addressing these things? How do we understand suffering as Christians, and to help Christians kind of work through and wrestle through some of those issues? Because I think a lot of Christians struggle with this, thinking, if it were me and if I were at that position in life, what would my decision be? So we need to be also having those conversations, and some good teaching, and so check out those resources, and by all means, please inform your constituency so that we can all respond together.
One more resource is something, Karen, I know you've been involved in, and it's actually a resource. It'll be kind of like a Faith Today magazine that's devoted to the issue of assisted suicide, palliative care, caring for people who are suffering. So what we've done is we've taken a number of articles that appeared in Faith Today over the last 18 months or so and packaged it together so that the articles are all there, and at the end of each article there's a series of questions to ask. So they're ideal for an adult Sunday school class or a home study to kind of walk through the issue and begin thinking kind of Christianly about the issue of pain and suffering, but also about the issue of assisted suicide and euthanasia. And so I think that resource is going to be available very shortly. The last thing, again, is to engage with your neighbors, talk with your neighbors about this issue, and then finally to, again, engage with your member of parliament. They're there to represent you, and so they need to hear from you. And you can do that as churches. The pastors need to engage with the politicians, but also as individuals in the community to engage with politicians and engage with them on an issue, brief them, Provide our resources. There's other organizations developing great resources as well. Make sure they're informed and make sure they know where you stand on the issue.
It does seem that this is an issue where different church groups, different faith groups are drawing together and working together in a really healthy, helpful, impactful way on this issue, and it's wonderful to see that, especially when it's clearly a life and death issue like this one is. We're going to wrap up, folks, and we thank you very much for joining us. I know there's lots of questions out there. We're going to continue to produce pardon me, resources to help. Everything that's been mentioned today you can find at the EFC.ca. And if you registered for this webinar, we will have your email address, I believe, and we can also send those to you by email. If you didn't, if you're just viewing it online, either now or later, you can email us from the EFC site. Or you can email me at senioreditor@faithtoday.ca, and we will make sure we connect you with the resources you need. So we thank you very, very much. And also to thank you, you can go to faithtoday.ca/webinar, and for the rest of the afternoon, you can subscribe to Faith Today for half price. That's the magazine published by the EFC, and we'd be happy to send you a copy of our most recent issue that includes an article on how to connect with your MPs and also an article on this issue. So thank you very much, and we'll see you next time. Bye-bye.